The health care law that millions of Americans have depended on, better known as Obamacare, is in danger of disappearing. Here's why. A judge in the state of Texas struck down the Affordable Care Act, also known as Obamacare. It was former President Barack Obama's signature piece of legislation, but through this judge's ruling, a key component of the law has been singled out as unconstitutional, and because of that, it puts the entire law in jeopardy. This is very important to point out. Despite the judge's ruling, the Affordable Care Act remains in effect while that ruling is appealed. What it means for Americans is if you want to sign up for Obamacare, you still can. The deadline, though, to do so is Saturday night. You'll remember President Donald Trump tried to repeal the legislation before. He tweeted that the ruling by a highly respected judge was not a surprise and was, quote, great news for America. In the meantime, the top Democrat in the House promises to intervene to hold what she calls the life-saving protections for people with pre-existing conditions and promises to reject the Republican effort to destroy the Affordable Care Act. Let's talk more about this now with David Katz. David, a former assistant U.S. attorney, joining us in Los Angeles this hour. A pleasure to have you here on the show, David. Thank you.
Great to be here.
Look, we've seen the Affordable Care Act survive legal challenges before. What is different this time around?
Well, after surviving numerous repeal attempts and after going to the United States Supreme Court in an earlier incarnation, this is actually a different Affordable Care Act than the one that went to the Supreme Court as the Obamacare Era 1. This one has the mandate, the individual mandate, removed from it as of next year. So as of next year, the judge says that this bill will be unconstitutional in its entirety because the original Obamacare was affirmed 5-4 by the U.S. Supreme Court, or upheld as being in force and being constitutional, because it was a use of the federal government's taxing power. But 5 justices would have said it was not proper as an exercise of the Commerce Clause. The Commerce Clause allows the federal government to affect interstate commerce, but it has to be significant. And so it was held in that case, George, that the Commerce Clause would not allow it. And so the fear now, and what has alarmed 130 million Americans with pre-existing conditions and 13 million people who signed up this year already for the Affordable Care Act, is that without the tax impact, without the individual mandate requiring people to either buy the ACA insurance or to pay a tax, that they're not the same 5, but that Chief Justice Roberts this time may vote to strike down the new Obamacare because it doesn't have a tax anymore. I don't agree with that analysis by the trial judge, but that's the fear that's shaking the land right now.
All right, so I just want to make sure I get this clear. So Obamacare was legal, the individual mandate was legal, and fining people who didn't purchase health care was legal. But as you're saying, once that fine was set at 0 by Congress, the whole thing now becomes illegal?
This trial judge seems to believe that the Republicans in Congress this last year, when Obamacare, quote, survived, that actually the Republicans had booby-trapped it, and that by making there be no mandate that was enforced by the tax laws, that they would strip it of its only constitutional basis, which was the taxing power. And so although McCain dramatically voted against it and the major repeal did not happen, apparently it was, at least for this judge in Texas, booby-trapped in a way that the whole thing was unconstitutional. Now, whether the Republicans were really that clever or whether this particular trial judge, he's a go-to conservative judge who's ruled, he's from the George W. Bush, he's ruled against Obamacare previously. So he was the dream judge for the state attorneys general who are challenging the ACA. We'll have to see whether it ever survives in the Court of Appeals, and we'll have to see whether it ever survives in the U.S. Supreme Court.
David, you know, we did get this statement from the White House. We'll put it here at full screen. We expect this ruling, it says, will be appealed to the Supreme Court. Pending the appeal process, the law remains in place. David, from your legal perspective, how do you see this playing out? What's the timeline?
Well, I think that it will take a while. You know, what's going on now is that the House of Representatives, once it's Democratic, Speaker Pelosi, to-be Speaker Pelosi, has indicated that the Democrats will join the lawsuit, move to intervene in it. It already has 12 to 16 state attorneys general who are going to be appealing it, including the state of California. It's enormously important to the health of Californians that Obamacare not be struck down by the higher courts. And then if it gets appealed to the U.S. Supreme Court, everyone's going to be biting their fingernails to see what Chief Justice Roberts is going to do. And there are ways to affirm to uphold the validity of the ACA, even with the revisions that were made to it. I believe Chief Justice Roberts will in the end. I don't believe that the ACA is going to fall. And in the interim, until the U.S. Supreme Court might say that it's invalid, I don't see any reason why it's going to be changed. I don't see the Democrats in the House agreeing to anything that the Republicans and Trump would want in the Senate. So as a practical matter, I think it'll stay in effect until and unless the U.S. Supreme Court, with Chief Justice Roberts casting the fifth vote, strikes it down. If that happens, all H will break loose.
David Katz, we appreciate your time. Thank you.
My pleasure. Thank you.